2026 changes everything. Most gun laws do not disappear with headlines or press conferences. They disappear quietly when courts simply stop enforcing them. Right now, heading into 2026, multiple firearm laws across the country are standing on fragile legal ground. Some are already blocked, some are under injunctions, and others are heading straight into courtrooms that have already rejected similar laws in the past. If you own firearms, magazines, carry permits, or even use a bank card to buy ammunition, at least one of these cases could directly affect you. Today, we are breaking down 7 gun laws that courts are actively moving towards striking down, and what that means for real gun owners, in real states, in real time. This is Survival Firearms. Let's get into it. Law 1. Illinois Assault Weapon and Magazine Ban. Illinois passed one of the broadest firearm bans in the Midwest, targeting commonly owned semi-automatic rifles and standard capacity magazines. The law went far beyond sales restrictions. It criminalized possession unless owners registered their firearms, with missed deadlines turning lawful owners into felons overnight. Federal courts stepped in after reviewing the law under the Supreme Court's Bruen framework. Key points. The court found no historical tradition supporting bans on commonly owned civilian firearms. Mandatory registration tied to criminal penalties failed constitutional scrutiny. A permanent injunction was issued, stopping enforcement statewide. The state appealed, but the stay is temporary and tied to appellate timelines. What matters for gun owners is this: once appellate review ends, the injunction immediately reactivates. If that happens, Illinois reverts to legal ownership of rifles and magazines that were previously banned without a legislative fix available to save the law. This case is widely viewed as one of the closest to full collapse heading into 2026. Law 2. Colorado Semi-Automatic Firearm Ban. Colorado attempted to pass a delayed enforcement ban, hoping courts would not act before it took effect. That strategy failed. The law restricted rifles, shotguns, and even certain handguns based on cosmetic features and weight thresholds, creating one of the most confusing firearm definitions in the country. Plaintiffs immediately challenged it under both the Second Amendment and Colorado's own constitution. Key points. Colorado's constitution explicitly protects individual firearm ownership. The same judge who struck down the state's magazine limit drew this case. The state lost its expert witness after historical analysis failed under Bruen. Courts are expected to issue an injunction before the law ever activates. This would mark one of the first times a major firearm ban is eliminated before a single citizen is charged under it. For Colorado gun owners, that means the law may never legally exist in practice. Law 3. Maryland Firearm Safety Act. Maryland's long-standing rifle ban survived for years under older legal standards. That protection ended with Bruen. The Supreme Court has already signaled serious doubts about the Fourth Circuit's approach, with multiple justices openly questioning whether bans on commonly owned rifles can survive constitutional review. Key points. The law relies on outdated legal reasoning rejected by newer Supreme Court rulings. Maryland has struggled to produce valid historical analogs. Internal preparations suggest the state expects Supreme Court review. Officials are already drafting fallback legislation to limit damage. What this tells us is simple. Maryland is preparing for loss, not victory. When courts intervene, possession bans are expected to fall first, protecting current owners and reopening lawful acquisition. Law 4. Delaware Assault Weapon and Magazine Ban. Delaware's law looks serious on paper, but legally it is one of the weakest bans in the country. Instead of writing something new, lawmakers copied Maryland's older firearm ban almost word for word. That shortcut matters because courts are already questioning Maryland's law under modern Supreme Court rulings. Here is why this matters to regular gun owners. Delaware did not just restrict future sales, it attempted to ban possession of commonly owned firearms and magazines, even for people who bought them legally years ago. That instantly put lawful owners at risk of becoming criminals without any change in behavior. Courts look very closely at laws like this. Under current Supreme Court guidance, states must show a long historical tradition of banning similar firearms. Delaware has not been able to do that. Why is this law likely to fall? The law is built on legal reasoning that courts are already rejecting in other states. Delaware fast-tracked enforcement before resolving constitutional challenges. The case is moving on an accelerated court schedule. Appeals go to a circuit court that has openly questioned magazine and rifle bans. For everyday viewers, here is the practical impact. If the courts block this law, Delaware residents would no longer face criminal charges simply for owning firearms and magazines that are legal in most of the country. Sales, transfers, and possession would revert to lawful status without the need for new legislation. That is why this case is moving fast, and why many legal analysts believe Delaware's ban could be one of the shortest-lived firearm restrictions ever passed. Law 5. Credit card tracking of firearm purchases. This is one of the most misunderstood firearm issues in America, and it affects far more people than rifle bans ever will. There is no federal law that allows the government to track gun purchases through your credit card. Instead, federal agencies pressured banks and payment networks to create a special transaction code for gun stores. That code does not show what you bought, but it flags firearm-related purchases for monitoring. For regular people, this raises serious concerns. If you buy ammunition, parts, or accessories using a card, your purchase can be flagged, stored, and reviewed without a warrant. That is what multiple states are now challenging in court. Why does this matter in real life? No judge approves this type of financial monitoring. No law passed by Congress authorizes it. Banks were pressured rather than acting voluntarily. Law-abiding customers are treated differently based on lawful purchases. Several states passed laws blocking this practice, arguing that financial surveillance cannot replace due process. The federal government responded by claiming the system is voluntary. Internal records tell a different story. Courts are now reviewing whether this policy violates administrative law and constitutional protections. If the states win, the tracking system collapses nationwide. For the average viewer, this is the key takeaway. A court ruling here would mean that buying firearms and ammunition returns to the same privacy protections as buying groceries, tools, or sporting equipment. No special codes, no silent monitoring, and no backdoor databases. This case is not about politics. It is about whether lawful purchases can be quietly tracked without public debate or legal authority. Law 6. New Jersey. Carry permit, special danger. After the Supreme Court ruled that states cannot require people to prove an extraordinary need to carry a firearm, some states tried to work around the decision instead of following it. New Jersey is one of them. Instead of openly defying the ruling, lawmakers replaced the old justifiable need standard with new language requiring applicants to show a special danger to life. On paper, it sounded different. In practice, it worked the same way. Courts saw through it. Federal judges reviewed the requirement under modern constitutional standards and found no historical support for forcing citizens to justify why they deserve to exercise a basic right. Why is this law collapsing? Courts found no founding-era laws requiring proof of special danger to carry arms. Changing wording does not change constitutional limits. Similar standards have already been struck down in neighboring states. Judges openly rejected the idea that rebranding fixes the problem. For regular people, this matters in a very practical way. If this rule falls, New Jersey can no longer demand that citizens prove exceptional risk just to apply for a carry permit. Permits must be issued using clear, objective criteria instead of discretionary judgment. That means fewer arbitrary denials, fewer legal gray areas, and a system that treats lawful applicants consistently. This is not about expanding carry beyond the law. It is about forcing states to follow the same constitutional rules nationwide. Law 7. The Hughes Amendment and the Federal. This final case is often misunderstood, so clarity matters here. The challenge is not about encouraging widespread access or changing everyday gun ownership. It focuses on a technical but critical question: whether a decades-old federal restriction was lawfully enacted in the first place. The Hughes Amendment, passed in 1986, froze civilian access to newly manufactured machine guns. Since then, enforcement has continued without courts fully examining how the amendment was approved. That is what this case addresses. Why are courts taking this seriously? The amendment was passed by voice vote with disputed records. Courts allowed discovery into official congressional documents. Judges ruled that procedural validity is a constitutional issue. The government cannot avoid review by calling it political. Here is what average viewers need to understand. Even if plaintiffs succeed, the ruling would be narrow. It would apply only to specific parties and would not immediately change federal law for everyone. However, it would create something far more important: judicial acknowledgement that the law may be procedurally flawed. That puts pressure on the federal government to either defend the law properly or revisit how it is enforced. This case matters not because of what it changes overnight, but because it exposes long-standing legal questions that have never been tested under modern standards. The quiet year that changes everything. 7 laws, 7 courtrooms, 1 clear direction. Across the country, judges are no longer allowing shortcuts, reworded restrictions, or silent enforcement to replace constitutional limits. These cases are not moving because of politics. They are moving because courts are demanding proof, history, and lawful process. For gun owners, the most important thing right now is not panic, and it is not rushing decisions. It is staying informed, because when court mandates drop, the rules can change overnight. Some of these laws will vanish quietly, Others will be rewritten under court pressure. But either way, 2026 is shaping up to be a turning point that affects real people, in real states with real consequences. If you want clear updates without noise, subscribe to Survival Firearms. When these rulings land, timing matters and confusion spreads fast. Stay informed, stay lawful, and I'll see you in the next update.